Do you have someone who's in? If not, I'll do it.
Good morning. Shall we get started? Apparently there's anyone here to introduce me, so I will introduce myself. My name is Ian Wilson. I'm licensed in California. I work for a company called Cardno WRG in Sacramento. My practice is, I started surveying in June of '88. My practice has been in private sector and public sector. I've worked for Caltrans, worked for small companies and large companies throughout California. I took the exam in '93 and passed. I took Nevada in 2010 and passed, and took Colorado last year and passed. So hopefully by the end of the year I'll take Arizona and grab that one as well. This is my oldest son, Nick, and his girlfriend, Erin. This was at Christmas this past year. They just got engaged yesterday afternoon. So, that's for Nick and Erin. The other thing that Rick wanted me to do, Rick is in the back of the room here. A question was asked yesterday about the test plan. It's available on the board website here, pels.ca.gov. And the test plan, according to Rick, comprises project management, 13%, research pre- and post-field analysis, 25%, field work, 20%, mapping and doc preparation, 28%, consultation and legal, 14%. I'm assuming that adds up to 100%, but I haven't done a quick check yet, but Rick likes to throw curves, so. The reason that this is up here is because if you go to the main web page, first of all, there's the license lookup at the top. So if you ever need to look up anybody's license, you can look it up by name or number there. But the other part is join our email list. And if you go to that, you get this screen here where you can subscribe, and you get wonderful email blasts about just about everything from board meetings and notes to whatever Nancy wants to send out. It's usually good stuff. Where do we want to go? Just a couple of logistics things, I guess. I have been presenting boundary and legal descriptions at the Sacramento chapter LS review class the last 2 years. We have typically 6 3-hour sessions to cover those 2 topics. So this is kind of a distillation of that because we've only got 4.5 hours to cover boundary. And boundary is what surveyors do. We are the only people allowed to deal with determinations of boundaries. Part of the fun of a seminar is that it's completely interactive. So even though we have a short period of time, I really encourage you to ask questions and to interact. This is your chance and your opportunity. Somebody last year once told me, for $100 they could buy, back in the day, they could buy 10 Kiss albums. The music never changed, they had 10 albums. But for $100 they could buy a ticket to a concert and go and see Kiss in person. And they always thought going to see them in person was terrific because they put on a great show and it was completely interactive. The band fed off the audience and the audience fed off the band. So I'm not equating myself to Gene Simmons, but Have at it. Quick PSA before I get started, though. This is not a zit. This was a thing that was frozen off my nose last week. We're land surveyors. We work in the field. We are subject to sun. Please go and see a dermatologist on at least an annual basis. Go to the American Dermatological Association website and the American Cancer Society website. You'll find information on skin cancer along with pictures of everything you need to worry about. For places on your body you can't see, solicit the assistance of your significant other. Keep an eye on it because this is a very serious problem for us. When I left Caltrans in 2003, my last tailgate safety meeting was in March of 2003. Within a couple of weeks, 3 guys came up to me and told me that they had had melanomas removed. 1 guy didn't make it to the end of the year. Bud Brown died in December of 2003 from metastatic melanomas. So please get checked. Boundary. As I said, boundary is the one thing that we are absolutely the only people in California charged with being able to do. It is, no other profession is able to determine where boundaries are located. No other profession does what we do. And the only reason that we do it is because we are licensed to do so by the board. And that license gives us the authority to work on behalf of clients to determine where boundaries belong. We do this for the safety and welfare and property rights of the people of the state of California, even though we're in Nevada today. Are there any Nevada people taking the exam? Great. Congratulations. First time? Excellent. Good luck. This is going to be a really interesting year because it's going to be multiple choice. Multiple choice can be a very simple exam, or multiple choice can be a very grueling exam. Nevada is, with all due respect, relatively easy. Colorado was one of the most grueling exams I've ever sat, including California's old exam. We don't know what's going to be on the exam, so unfortunately there aren't a whole lot of problems that we can work through together with this, so we're going to work through examples more than anything. We went through the same thing in '93 when I took the exam. It was the first year there was a secure exam and everyone was terrified about what the exam was going to look like. Because prior to '93, you could take the exam home at the end of the exam. And so everybody was terrified about what would happen in '93 and what we would face. It obviously wasn't that bad because the board made the mistake of passing me. Boundary surveyors. We're a very ancient profession. In fact, what we do goes back tens of thousands of years, to be honest. What I really want to do with this class, rather than set you up with a set of rules and let you go, is help you understand exactly where these rules come from and what the thinking is behind this. Because what we deal with on a daily basis today has its roots back tens of thousands of years. If you think about it, 10,000 years ago, we were nomads, started slowly settling down to be able to make good beer, which is where society and civilization came from. And we were typically little family groups that were associated in clans. Okay, we might have 2 or 3 different clans that we're associated with. And we covered a territory that was given to us by the Creator, by whatever our creation myth was. And we were given the land, and given stewardship over the land, from the salt water in the east where the sun rose, all the way to the mountains where the sun went to sleep at night. From the forests up in the north where the strange people were and the wild animals, all the way down to the trackless desert down there. And that's a legal description. That's our land. You can't come on it. We're going to defend it. And if those people come out of the forest in the north, we're going to go and fight them. We own this. It was given to us by the Creator. That, by the way, is one of the most important concepts in ownership of land, in property rights. We own it. We exclude other people. It's mine. You can't come on it. Fast forward a few thousand years, and we have the Sumerian culture. The three oldest known written documents are Sumerian clay tablets. Depending upon who you talk to, they are either a love poem, that's my wife, 60 feet below the surface off Lanai, a recipe for making beer, that's my blue ribbon for first place for my Scottish Ales at the 96 Home Brewers Association competition. By the way, second place was Dan Gordon. He's the brewmaster for a little company called Gordon Birch. And the third document is actually a deed for some bottomland. That's my license stamp in California. So I've got all three of those documents covered. There's my CV. So the Sumerians also established, here's our ocean again, the ability to grant property rights. This is the house of a Sumerian noble person. And the king gives him the property. And he sets, or causes the surveyors, the rope stretchers as we were known, to set property corners. And each of those property corners, by the way, had the deed description for the property actually on the cornerstone, so you could actually go and read what the deed was. You didn't have to go down to the recorder's office. But that meant that that person had the rights to that piece of property. Basically what it meant was they were stewards of the property. For example, this person might be someone who is very skilled in growing grain and barley for making beer, or grapes for making wine. So they were given access to this piece of property because it was one of the best pieces of property to be able to do that. It did not mean originally that they could do anything else with it. They couldn't sell it. They couldn't pass it along to their children. It was theirs for the duration of the king's pleasure. Then, as time went by, we got the idea that these people actually could own land and they could do with it as they chose as far as getting rid of it down the road. Usually, the first step in any culture going to land ownership was a concept called primogeniture, where, sorry ladies, and second born, the land goes to the oldest born son. Everything, title, the whole bit. The women, second born sons, third born sons, they're out of the picture. Our land law, as it exists today in the United States and California, extends back to Norman land laws in Europe. Normans came across from the continent and conquered England in the early 10th century and brought many of their words and terms and things that we still use today. Anybody ever heard the term fee title? Fee is a Norman word. Hereditament, that's a Norman word. Inheritance, that comes from a Norman word. So even today, 1,000 years later, we're still using ancient Norman words in our land descriptions and in our land transactions and legally. This is part of why we need to understand history, because boundaries are history. They're not making any more land. Well, that's not true. There's a couple of places they are, but they're not really great places to live. Iceland and... So what we have has to be controlled by a very distinct set of laws, and these laws are very, very ancient. The idea of adverse possession. Of Hammurabi's codes, at least 3 of them dealt with adverse possession. So you're talking about a concept that goes back 4,000 years and is still around today because it's an extremely useful tool. The idea of property ownership is so important that it was actually written down in the Torah, the book of Nevi'im, which is also equivalent to the Christian Bible's Jeremiah? Yes. This is actually in our holy book. Boundary is so important that we have it codified right in the Torah, in the Bible. We also today have it codified in a set of laws and the statutes of the Business and Professions Code that we call the Professional Land Surveyors Act. 8762 of the Professional Land Surveyors Act deals with what the profession can and can't do. In particular, you are practicing land surveying and must have a license to do so if you locate a boundary. This doesn't give real estate agents an exemption. It doesn't give attorneys an exemption. It doesn't give judges an exemption. It doesn't give property owners an exemption, at least for the documentation. Makes any survey for a subdivision. Again, no exemptions, only PLSs or civil engineers registered prior to 1982. Set the positions for monuments. That's solely a land surveying function, no exemptions. Determines the information to be shown on a document, map or a deed. That one's a little gray area. There are a few sort of slide exemptions for public utility employees of a certain size, as long as they put certain verbiage on the deeds that you generally never see.
That's a section for reputable surveys. It should be 80.
Say 726. You're right. Good call. I'm dyslexic, by the way. So boundary that we're going to talk about today is created by the PLSS, sequential conveyances, and simultaneous conveyances. Interesting, the whole concept of the PLSS was developed in the 1700s when our forefathers determined or had the foresight to realize that the United States would probably expand all the way west to the Pacific Ocean eventually. And they saw that it would come in huge chunks. And we needed to be able to identify what smaller tracts of land were, how to find them in the wilderness, and set them up in a catalog system so that the government could get rid of them quickly. Part of that was to be able to pay for things like the Revolutionary War, the War of 1812, and all the other government. Sequential conveyances. There we go. Sequential conveyances are the way that land was originally subdivided in California. And private citizens could subdivide land by deeds until, anybody know the date?
March 4th, 1972.
March 4th of 1972, the magical date. Wait a minute. A sequential conveyance, a common grantor subdivides lands into smaller parcels by deeds that may be recorded and may not be recorded. But the idea here with sequential is that these deeds are recorded in a chronological or developed in a chronological fashion. For example, we have a large tract of land and the owner decides to subdivide and sell off a portion of it. does this in 1964. Later on, sells off another parcel. Later on, sells off yet another parcel. So each one of these parcels has been created sequentially. And each one of these parcels have different positions in time and different rights based on that position in time. Of these 4 parcels here, the guy who has the most rights is the 1964 document. It came out first. Part of the idea behind this is a simple idea of criminal fraud. If, as the original owner, I try to sell off some of that land that I sold off in 1964, I'm selling the Brooklyn Bridge. It's something that I don't own. I don't have the right to convey that land because I've already conveyed it. One of the reasons for this slide is the fact that you notice the bit in the middle there that doesn't have a date on it. That was the original parcel. It's technically junior to all the other parcels because it's everything that used to be there except all the other 3 pieces. And it's not uncommon to run into situations where you're dealing with deeded property and that's the piece of property that you're dealing with. Most of the time, if you run into a situation like that and you don't have a document that says, here's my deed, you're going to be asked by the local jurisdiction to provide that history and apply for what's called a certificate of compliance. The certificate of compliance says, yes, this complies with the Subdivision Map Act and it does meet all the legal definitions. Bada boom. And yes, that does happen relatively frequently. Even though we have not been allowed to subdivide private land in California since March 4 of 1972 by deeds, we run into these on a regular basis because from the time that the state of California was created until March 4 of 1972, everything was subdivided by deeds with few exceptions. I believe it was the city of Glendale had subdivision ordinance, a rudimentary subdivision ordinance in place back in the late 20s. So there's been bits and pieces of subdivision regulations around for quite a while. Okay, so we've got this little deal here. The reason for this slide is because the concept that we just talked about, the fact that the 1964 owner has the highest right to that land, he was the guy who got it first. Everything else comes after that. Surveyor comes in, or whoever comes in and sets these monuments here to mark the westerly edge of the 1966 parcel. There's a problem because that's actually been set in the 1964 parcel. So the guy, whoever purchases the 66 parcel, has no right to that. They do still hold some importance in that we treat them pretty well like closing corners in the PLSS. We hold them for line, but not for distance. The distance would be the easterly edge of the 64 parcel. Is that clear? Because that's an extremely important concept before we move on. Problem with deeds is that there are very few deeds, unless I wrote them, that actually do not have conflicts in them. There's always some element of conflict. And in reading the deed, you have to be able to determine what that element is and how to resolve that conflict. Here we have 2 pieces of property that butt up against Blue Lake, and the line around there is a low water mark. 2 owners. Dates become critical on this because this helps us to understand junior and senior rights that we'll get into. So we have a description. East 200 feet to a 4x4 post in the west line of Wilson. And it should actually be green. Bada boom. Wilson might have been a previous owner. And you'll find that. You're looking at a deed and you're looking at 3 or 4 generations back in title. So there's our 200 feet to a 4x4 post, not in the west line. Thence north, 20 degrees east, along said westerly line, 450 feet to a 2-inch iron pipe at the low water mark of Blue Lake. Well, the iron pipe is not quite at 450 feet. The iron pipe is not at the low water mark. What do we do? And that is an example of what we face relatively regularly in dealing with deeds and in dealing with boundary determination. The problem is we have conflicts, and it's our job to understand what the conflicts are and resolve them on the ground. We have a hierarchy of conflicting deed elements. They're really just a set of rules that the courts use to help resolve the discrepancies. What's important, one of the important things to take away from this is that even if we have two owners who own property side by side, in a conflict situation where they go to court, they're going to go, first of all, in California to the Superior Court for a ruling in the Superior Court. Typically, the Superior Court uses ideas of equity in determining where they want the boundary to be. And as one judge in Porterville once told me, if he can piss off both parties equally, he's done his job. Great. Unfortunately, the lower courts don't often deal with good land law. Part of that is because what we deal with in boundary law is really a very, very small subset of the law of real property. And has anybody been to law school? Do we have any attorneys here? Paralegals? Good. In law school, real property law is one of the classes that's known as a weeder class. Everybody's got to take it, and it's a bugger. And it's designed to weed out inferior students by failing them, essentially. Every subject has a weeder course at least. But in real property, most of what's covered during the entire semester is conveyances, the actual transactions involving conveying land from one party to another. Most of the time, if there is anything that deals with boundary at all, it's 1 2-hour lecture, if there's even one at all. So the actual law that behind boundaries is a very, very small, very obscure set of laws relative to all of real property and to all of the practice of law. So finding attorneys or judges who know much about boundary law is very, very rare. It's not to say it doesn't happen. There's some damn good attorneys out there with some very good ideas about boundaries and boundary law. But for the most part, they're relying on us. That's one of the reasons why we're licensed, because we deal with boundary law. We are one of the few groups of people who deal with boundary law on a regular basis. And it's important for us to understand what's going on because boundary is the most important concept for land surveyors. It's why we're licensed more than anything. We need to be able to work with the attorneys and work with the courts to be able to bring forward some of these ideas. It doesn't always work really well, but we try. So there's a hierarchy here of all the different items in that may appear in the deed that are used by the courts to try to establish where property lines should be placed. Unwritten rights. Unwritten rights is the highest order, the highest rank of any of the rights in property ownership. Unwritten rights are things like adverse possession, oral agreements, anything that's not written down that two property owners acquiesce to a boundary line. And that acquiescence can, over time, ripen into a full fee ownership line. And as I started to say earlier, the really interesting thing about boundary law is that Joe and I have property next to each other. And we have a dispute about exactly where that property line is. And we sue each other. We go to Superior Court, we dump $50,000 on the table, roughly, and get a decision at the Superior Court level. Joe says, that's ridiculous, and he appeals. So we dump $150,000 to $250,000 on the table each, and it goes up to the appellate court. And the appeals court comes out with a decision, and I say, that's ridiculous. I'm appealing. So now we're going to dump about $1 million on the table, if we're lucky, and go to the state Supreme Court. And they're going to make a decision. And Joe and I walk out of the court and look at each other and go, you know what? That's screwed. Why don't we do this? And there is nothing that says we have to do anything different. Not one of the courts can enforce their decision because it's our land. That's pretty powerful.
Do you have written rights that takes precedent over unwritten?
And that depends. The unwritten rights have the highest order, but as in every case with boundary law, there may be a written right that can be shown to supersede that right. But it takes quite a bit to overcome that. Getting the idea out there of what the unwritten right actually is a very hard thing, because remember, there's not much of a record of what it is. There's no document that says, hey, Joe and I agreed to this in 1968. So, 4 or 5 generations of landowners later, how do we decide that that's actually what happened? You look at some of the appellate court decisions and you'll see cases where written rights have trumped unwritten rights for good and bad reasons. Bryant v. Levins is one of them.
It's my understanding that the courts don't favor unwritten rights in California. I mean, adverse possession is a very hard thing to prove.
Yes, it is a very hard thing to prove for a very simple reason. Unwritten rights generally fall under the presumption of hearsay, which is me turning around to the court and saying, I heard that she said. Well, the court really doesn't like me telling them my interpretation of what she said. What they really want is her to sit on the stand and say, this is what I said. Unwritten rights are very difficult to prove, but once proven, they're very difficult to overcome. We'll get into some of the ideas of adverse possession a little bit later. Senior rights. We just saw in the sequential conveyances of property that senior rights have a higher order than almost anything else. Unfortunately, senior rights really, when you're relying on something like senior rights, you're looking at a pair of deeds or a handful of descriptions. They're really very poorly written, and you're trying to figure out who has the senior title and where that senior title line is. But once that's been determined, generally, that's going to be the line that holds. Written intentions of the parties. This is a subject that on the forums you'll see all kinds of things written about what's going on. Written intentions of the party, the intention of the parties subdividing the land, if it's not in writing, it's very difficult to come up because, again, it's like hearsay. It's like unwritten rights. We've got a lot to be able to throw on the table and prove to come up with any idea of what's going on with the intention of the party. In fact, a lot of time, if I'm actually writing a legal description, there's any possibility down the road that there might be a misconstruence of the reason for what we're doing. Like a couple of deeds that I wrote Thursday for a couple of bike trail easements up here at Tahoe. There's a description, and down at the bottom is the intention of this description to convey an easement for bike trail purposes over a portion of the property abutting Highway 50, I think it was. So anybody down the road looking at that with a dispute is going to sit back and go, well, I think it's over here, 20 feet away from the road. the intention is written right there. No, it's not. It's smack up against the road. So it's leaving something for people who are coming afterwards. Because remember, this dispute might not happen next year. It might not happen for 50 years. God forbid, 50 years from now, I'm gone. So nobody can ask me what's going on. Most of the parties to the easement are already dead. So all that's left is the writing. Not to step on legal description class. Have you already had legal descriptions, or is that coming? Okay. Not to step on his toes, but if there's any chance of putting the intention of the parties in writing in the document, do it. One of the things that we're told to do as land surveyors, and you've heard it all the time, is we're to follow in the footsteps of the people who went before us, the surveyors who went before us. But nobody ever, or very few people ever, talk about the corollary of that. We should be setting footprints for the people who come behind us. Now, how many times you go and you're doing a boundary job, and you know that there's been somebody out there before, damn it, holy mother of God, it's like I'm trying to track somebody walking in moccasins over glacier-washed granite. Where the hell were they? Leave footprints. Intention in the deed is a great way of leaving a footprint. This is what we're intending to do here. Calls for a prior survey. Most of the time, legal descriptions are not written with the benefit of a survey, which is where the discrepancies and the problems come from. But if there is a survey and there's a call in the description for a survey, then that survey is included in that description by definition. It may not be easy to find that because that may not have been a recorded survey. But if there is a call for a previous survey or prior survey, and you can find that survey is going to do a lot to control what's going on with that deed. Any questions or comments or examples? Or
How about you have a survey with errors, prior survey?
Well, there again, one of the principles of the survey is the original undisturbed monuments are, unless you can prove that they're absolutely grossly in error, are going to hold. And we'll see an example of that a little bit later on.
Couple comments.
Yes?
These are just more for practical purposes, but there are some large pits to fall into out there.
Oh, yeah.
In California, it's called a lot line adjustment.
No, that's not a pit.
Oh, that's a pit. When the lot line adjustment, well, maybe it's a canyon, where a lot line adjustment has actually, the description has been made by the property owner, and it makes no sense whatsoever, and it's been accepted by the county. And it has been filed.
Okay.
Yes, I come from a county where that happens. Also, we have a particularly, I'm not sure if incompetent or corrupt would be the proper word, assessor, wherein assessor's parcels are suddenly brand new deeds.
What county are you from?
Contra Costa.
Oh, God. Okay. Enough said.
So, watch out.
Yeah. Let's get a little bit further down the line here, but I'm going to put that on there to make sure that we do discuss that. That's an extremely important function. Yeah, we'll get into that. Lot line adjustments are a topic that's near and dear to my heart. 6 sentences in the Subdivision Map Act that are probably the 6 sentences in all of the statutes in California, criminal and civil, that are the most misinterpreted. There are, I'm just trying to remember, 498 recognized jurisdictions in California as well as 58 counties. So you're dealing with well over 500 different agencies. And I have yet to find 2 agencies that handle lot line adjustments in the same way.
We need to change the law.
Yes, we do. I'm chair of in fact, the gentleman back there No, it wasn't. It was Mike Butcher. Stuffed me in as the chair at the state level to take a look at the lot line adjustments and see if we can come up with a way to make it a little more understandable. Those 6 sentences are incredible. I think it's like 300 words in 6 sentences. It's wild. Calls for monuments. A call to a monument is a call to something physical. You remember our description about the forest in the north, and that's a valid legal description. Natural monuments are wonderful things, and so are artificial monuments. The reason natural monuments come above artificial monuments in the trail here is because it's a little difficult to move a natural monument. If we go from the shores of the Salt Lake where the sun rises, it's not easy to move that. But we can. I mean, we've got the 2 quotes from Jeremiah that say, don't move the stones. Well, there's a reason for that, because people were moving the stones. That's why natural monuments come above artificial monuments. True case. Over here, I think it was Alameda County. There's a gravel mine. The legal description for the gravel mine is very well established, and it actually calls for some monumentation. The seam of gravel extends a little bit further west than the property line. Well, the monument was moved 127 feet west, and the mine was further mined. Gravel was extracted. What's amazing is that there was a huge tree very close to the corner where the monument was originally set. Had that tree been called out as a monument, it would have been a lot harder to move a 3-foot diameter oak as opposed to a 1-inch iron pipe. So that's the reason that natural monuments come above artificial monuments. We were able to determine that the pipe had been moved based on a whole lot of other things going on there, but it's a big deal. You know, we've got to say, yeah, this pipe was clearly moved. So we've got a lot to overcome with a tree. There's the tree, there's the gravel pit. What are we talking about?
Seeing how it's against the law to tamper or remove a property corner,
Mm-hmm.
if they cut that tree down, would that be considered destroying the monument?
Yeah, I suppose. Well, not really, because you're going to have a stump to deal with, roots to deal with. There's, Steve Parrish will tell you all kinds of stories about finding trees that have been dead for God knows how long and proving boundaries because of it.
But it still falls under that category as a monument, not to be removed.
Yeah.
Even though it's a tree.
Has anybody seen the government, the federal tags, the big discs that they used to have stamped on them, $250 fine? They don't have that anymore. Anybody know why? Nobody ever got prosecuted. I don't know of a single case in California or in the country where anybody's been prosecuted for destruction of monuments. You're going to go to a DA and say, yeah, I want this guy prosecuted for destroying my monuments. It's like my truck got broken into a couple of weeks ago. Try to get a policeman to come out and take a report. No, they give you the link to file the report online. It's one of those victimless crimes that it's a monument, big deal. I mean, fence companies destroy them all the time. Rat bastard surveyor put a pipe right where I need to put the fence post. Get it out of there. Record lines or adjoiners. If you're calling for a record line, you're probably looking at senior rights, which might come up higher, but there are other record lines that you'll be looking at, like a line parallel with a senior line up there, or an adjoiner's line. Now you've got to determine who actually has senior rights there, further up the line, to establish what you're going to do with that line. Calls for directions or distances. The idea of what we do as land surveyors is we're supposed to be expert measurers. So we ought to be able to measure everything expertly. And your measurement and my measurement ought to be the same, right? Yeah. When I deal with clients and they're asking why my measurements are different than the record measurements, one thing, the example that I use for them is if I take a jar of jelly beans and put them up here, and you count that jar of jelly beans, and I count that jar of jelly beans, unless you're in Florida, we should come up with the same number. Political statement. Why? Because you either have a jelly bean or you don't have a jelly bean. It's an integer. It's a thing that is or a thing that isn't. Now, if we measure, we're not dealing with an integer anymore. We're dealing with a fixed thing, say the width of this podium. But we're using a ruler or a measuring system. Where do we start with on that ruler? Do we... We got 4, 5, 6. Okay, there's the ruler. Do we start on that ruler here on that line? Do we start here? Do we split it in the middle? What happens if whatever we decide with this podium, that's supposed to be right up against the line, it's like that. How long is the podium? Well, gosh, we're estimating in here. And of course, I'm licensed, so my estimation is much better than yours. Just kidding. And that's why we have the problem. Because measurements also carry error. You go down and talk to the guys downstairs, and God bless their hearts, this will measure, plus or minus 200s, 200s plus or minus 1 part per million. Okay. Bottom line, there's an error there. And we have no idea where that error is going to fall relative to our measurement. So with any kind of a measurement, we're going to have a problem. We try to deal with that as best we can. The other one is we have linear measurement, but we also have angular measurement. One of the things that I always talk about is the fact that if you go out and set up 3 pipes today and measure them yourself today, go back next week and the week after that, you're going to end up with 3 different measurements for that angle for a whole lot of reasons. Equipment problems, centering the tri-brac, adjusting the tri-brac, where you're actually going to sight. You're looking at a crosshair, and that crosshair has got a thickness. Where are you going to put that on the object? There's always going to be some error there. That's why measurement comes way down the list. In our set here. That's a direction and a distance. Should actually be, okay, we've got direction and distance, or distance and direction. A really interesting thing about that is that across the country, this will change depending upon what state you're in. Some states, distance has a higher precedent than direction, and other states is exactly the opposite. Which is one of the reasons why a national survey license is probably never going to happen. Calls for area. This is a really common type of legal description that occurred particularly in farming areas, or areas that are going to be farmed. The whole idea of farm, anybody know what an acre means? Originally, the idea of acre was how much land a man could plow in a day with a team of oxen. Well, there's a problem with that because if you've got really nice, easy land that's down in the river bottom, you can plow a lot of land in a day. And if you got some rocky crap up on the side of the hill, your acre is going to be a whole lot smaller up there than it is down in the bottom. So it wasn't really until about the 1600s that there was a standard developed for what an acre actually is, which is one of the reasons why we have the chain. Because the chain actually was developed to measure acres. Anybody know the chain definition of an acre?
1 chain by 10.
Yes. 10 chains square. As opposed to 10 square chains as opposed to 10 chains square. Because you've got 10 chains squared. That's 1 chain square, 2, 3, as opposed to a big square all the way up there. Whoop. iPads are fun except when they're not. So even down to our measurement, I mean, we're talking about areas. That's how the chain came about. The PLSS system uses chains because chains help us to determine areas. And areas are what we're selling to get rid of it very quickly. And it's still going on. We're still running into deeds like this. A couple of weeks ago, I was dealing with a piece of property in Riverside. No, it wasn't. It was San Bernardino. Built-up area. But it was subdivided originally out of farm lots. And the piece of land that I'm dealing with is the farm lot 900, accepting therefrom the easterly 10.66 acres. So now I got to find out where lot 900 was. Then I got to figure out where the easterly 10.66 acres is. And where does that line go? We'll look at a little bit later at some rules of construction for that. But that holds up in court. That's what the description was. There's nothing in there about measurements or distances or anything. It's lot 900, and then we get rid of this 10.66 acres, and what we have left over, that's our lot. Well, holy mother of... That's not an easy thing to do sometimes. We're talking about errors in angles and errors in distances. Now we're multiplying that because we're determining area. My favorite. We'll get into this in a little bit. We'll just leave it on the table right now. Calls for coordinates. Unwritten rights. Parole agreements. This is not the document that the parole board gives people. Okay, that's spelled a little differently. This parole, anybody remember where our land law comes from? That's a Norman word, and it means spoken. It's 2012. We're still using a word that the Norman kings used in the 10th century. Parole agreements. Anything that's an oral agreement. Joe and I have two pieces of property next to each other. Hey, Joe, it's a pain in the neck for me to cut to here. You know, why don't you mow that bit? He's like, okay. So we now have an agreement. Down the road, it's like, you know what? Whatever. That's the boundary line. A parole agreement. That's an unwritten right. I happen to like blue fescue. And Joe likes St. Augustine. So now there's a real distinct line between the two of them. So you go out there and you do a boundary survey, and you're coming in and going, wow. There's this really crappy St. Augustine, this beautiful blue fescue. And that line doesn't match. There could be a reason for that. And there could be a parole agreement back in history that y'all need to take a look at. Because now it's actually Joe's grandson who owns a piece of property, and he says, yeah, Grandpa liked St. Augustine, and this is where they decided the boundary line was going to be. Could it happen? Yeah, absolutely. That's the kind of thing that we're charged with looking at as land surveyors. That's a little above minimum competency for the exam, but once you're licensed, you're going to have to deal with this. And you get licensed this year, 20 years from now, look at the boundary work that you did this next year. If you agree, if you would make a different decision 20 years from now that you will make this year, you are normal. If you would make the same decision 20 years from now that you make this year, you haven't learned a bloody thing. Most of the time, the decisions that I look back on haven't really damaged anybody. And I can still justify them today. Just don't really want to make the same one. I'm sure Bill's the same way. I mean, holy, wow, I did that. Acquiescence. I seed my lawn, and it's 2 feet over into Joe's property. And he goes, whatever. He's acquiesced to where that line is, or might have. So now we've got another thing. You know, we're looking at this line, and here's the property line here, and the really good grass up to here, and 2 feet over, and then all this really ugly St. Augustine. Why? Prescriptive rights. Been doing it so long that I have a right to do it now. There's a court case in California. There's a guy lived in the house that he was born in, walked from the house over to the river for years and years and years, fished there every week. They expanded the local runway and cut off his ability to go to the river. And he sued for prescriptive rights. And they actually settled. But the settlement was that the 2 airlines that serviced that airport gave him free flight anywhere in the world, anytime he wants, for the rest of his life, as long as he gave up the right to that path. That's pretty expensive. A very big deal. I did a survey for a bank of a piece of property. This was a whole set of industrial buildings here. This over here is the bank property, completely blank. Well, there's a little bit of a bank between the two of them. There was a very, very hard packed area like this. And there's a basketball hoop there. And there's a machine shop here that had been there for about 20 years. And at lunchtimes, when the weather was good, these guys would spill over here and play basketball. So when I did the survey of this property here, I located this and noted that there may be prescriptive rights. So I noticed while we were out here doing the surveying, these guys came over and played basketball. So I went down and found the owner of the property, the business here, and talked to him about it. And he told me what had gone on. Yeah, they've been doing that for 20 years, and they get some competition in there from time to time on a Friday afternoon with other businesses, and they've been playing for years. So the lender called me and said, what the hell are you doing? You're screwing this up. Or the seller said, no, you may have a problem here. Well, the attorneys got involved and went, uh-oh, what do we do? Well, whether the developer here, when we talked to the developer, they decided, part of the parking lot, if we popped out a little area like this and put in a picnic bench here and a little basketball deal right here, and got these guys to sign an agreement that said they had no rights to this, that we could give them a license to come up here and use this from time to time. And they signed it. So they fixed it. Was that a silly thing to do? This guy's brother was a real estate attorney. What would happen if we just tore that down? Yeah.
So if they give them a license to use it, that means anytime they want to, they can say you can't do that anymore.
That's exactly right. It's a license. We're giving you permission, and we can revoke that permission at any time. A lot of times, if you're in a city where the sidewalks are actually built on private property, Carlsbad is a perfect example of that, downtown Carlsbad. You're walking down the sidewalk and you see little brass plaques, two of them right next to each other, and you walk to the other side of the store and there's another pair of them there. If you look at them, it says right to pass given by permission of owner. That means, I don't care if you've been walking over this sidewalk for the last 25 years, if I say you're not walking here anymore, that's the end of it. You can't ripen that into anything other than my agreement to let you walk over here. That's why that brass is there.
Is that also a written document that's recorded somewhere as well?
Nope, doesn't need to be. It's right there on the ground. It's presumed that if you're walking over that sidewalk, you're going to look at that brass and read it, and if you don't, tough.
Is that also documented, say a survey is done on a piece of property, does the surveyor have the obligation to say that those plaques are there?
What would happen to the surveyor if he didn't document it and there was a problem down the road? He's got some liability there. Another perfect example of prescriptive rights that you really should be looking at if you're doing any land title surveys. Let's see here. Actually, let's take this one over here like this. You got a case here where you're doing a land title survey, mistakenly called Altas, for this piece of property here. I'll get into that in a second. These properties are both occupied. You see dirt tracks that go back this way and a gate in the fence here. You fail to notice that gate on your land title survey. You're really doing yourself a great disservice, because this guy says, well, we need to get back here from time to time, and for the last 15 years, we've just been driving over this empty lot and through the gate. Why do you put a gate in a fence? It's not because you had 10 gates in the yard and they were cheap, so you're just using a gate instead of a section of fence. The gate's there for a reason, and that's to go through it. And if they're going through it, then they may have acquired some rights here. The Frito-Lay's warehouse in Murrieta, situation like that when they did the land title survey. Fortunately, it was determined that nobody would really use that property on a regular basis for any length of time to be able to determine any or gain any prescriptive rights, but it was noted on my survey because I like to have my house and I like to eat. And a lawsuit would have wiped out those in a heartbeat. We get to go to 10 o'clock? Okay. Adverse possession. Adverse possession is a topic that is really misunderstood. Some people call it legalized land theft. In actuality, what it is as we said earlier, a concept that is so old, it goes back to, you remember that, the brewer who was given the piece of land by the king, because they're really great brewers. They have the right to use that because their best use for that piece of property is that person growing grain and brewing beer better than anybody else in the community. So that's where their right, their stewardship of that property comes from. Now let's say that person gets called up and goes away to war. Or for some reason or other, they take off for a couple of years and they're not around, and somebody else comes in and starts using a piece of that to grow grapes. The barley isn't being grown on that anymore for making beer, so now there's a guy using this for growing some grapes. Adverse possession says the guy who's growing the grapes, after a certain period of time, is going to have title to that land because he is the best user of that land. He's the steward with the community's best interests at heart by brewing or fermenting wine. That's the concept behind adverse possession. The three pieces from Hammurabi's code actually are codes that stop claims of adverse possession. If a soldier is away at war and not able to take care of his property, you cannot claim adverse possession against his property for a period of 3 years after he comes back. So if he's away at war and somebody else is using the property, he comes back from war, he can throw you off. A minor child, if a soldier is away at war and killed, and his son inherits the property, you can't claim adverse possession against the child's property until he turns, 18. And this is right there in Hammurabi's Code. You can actually read it on the internet. This is 4,000 years old. Why is it so useful today? Because as we moved across the country, yes?
I was just curious, does that same kind of statement go like if someone was arrested or someone was just overseas?
We don't have that codified in California laws, but yes, there are. By the way, those codes that I was talking about are Hammurabi's codes, not California code. You're not going to be tested on Hammurabi's code, I hope. But yes, there are some adverse possession statutes that talk about people in jail, people in hospital, people in lunatic asylums, people who are away at war or overseas. It's a possibility, yeah. Because adverse possession, what that does is it says there's this title here that came up to here. We're throwing all of that away and starting a brand new set of title that starts off with the adverse possessor. Prescriptive rights just say, we have this chain of title, but you're going to be allowed to use it for a certain period of time. Yes?
You mentioned there were 3 codes that had to do with adverse possession?
I can't for the life of me remember what the third one,
Sorry.
but it had something to do with females.
Probably a good thing.
We'll leave it at that. So why is adverse possession still around? Because it's extremely useful. As we moved across the country, you'll find that the periods, interestingly, the periods for adverse possession, if you look at the statutes across the country from the East Coast to the West Coast, they get shorter and shorter and shorter and shorter as they come across the country. Why? Because as we came across the United States, we started acquiring bigger and bigger and bigger chunks of ground very, very quickly, and we had to get rid of those Indians that were causing trouble. They had prescriptive rights. So we just throw in some adverse possession, say 5 years, and 5 years later, it's ours. Also, you have a problem with, early on in history, particularly California, some rather dubious claims to property. So in order to bar stale claims and completely inundate the courts with all kinds of land law claims, in California, the statutory period is 5 years. So if you've possessed a piece of property, there's a whole lot of other things going on there, but if you've possessed a piece of property for 5 or more years, a claim against you is barred. Which doesn't mean you can't make it, it just means that you go to court and lay it out the facts and the judge is going to make a decision. But it's extremely useful today. Excuse me. It's also still coming up from time to time. And if you go to, the one thing that I missed in talking about earlier, Superior Court decisions. They're written decisions, but they're not recorded in such a fashion that we can get to them to review them. At the appeals court level, you have 3 judges, minimum 3 judges, who are coming up with the opinion. They vote and decide one way or the other and come up with the opinion, and sometimes a dissenting opinion, that is recorded in what are called reporters. We have a bunch of them here that cover California, the Pacific Reporter, California Reporter, I don't know. I have some court cases coming up. There's a very specific way to reference those cases, and there's a very specific way to be able to search for cases like that, to deal with different things. Those opinions are the court's judicial thinking and why they came up with that decision. It's critical as land surveyors that we begin to read those and understand them, because over time there are incremental changes, sometimes very small changes, that change the way judicial thinking happens. And when I do a really difficult boundary, my analysis of that boundary often includes me sitting there and looking through different court cases and saying, if I'm on the witness stand, what court case am I going to use to justify this position as opposed to that position? There are still adverse possession cases going on today. Generally, in a mapped subdivision, you're going to have a very, very hard time getting adverse possession against anyone in that subdivision, for the simple reason that in California, you're also required to fence the property and pay taxes on it for the statutory period. Most of the time in California, the way the taxes are levied on a piece of property is based on the subdivision map. So you're being levied on parcel 1 of parcel map A. In the old days with deeds, where you had nominally, let's say, the east half of a 40-acre parcel, you're getting taxed on 20 acres. 40 divided by 2 is 20. What happens if it's not 40 acres? What happens if it's 39? You know, you've got overlap there. And there's a famous case where there was an overlap, and the claim of the strip that was an overlap went under a claim of adverse possession, and they were able to say, hey, we've been paying taxes. Everybody thought it was a 40-acre parcel. We've been paying taxes on 20 acres. He's been paying taxes on 20 acres. It's only 38 acres. So I've been paying taxes on this strip for ages. So that's a very difficult thing to prove, but it's still being done in certain cases. One of the things that we talked about earlier was when I own this piece of property, I have the right to kick you out or keep you off. That's an extremely important right to property ownership. It's mine. You can't come on. There was a case decided a couple of years ago, Blackmore, in which the claim of adverse possession was made initially because there was a strip of land over which an easement was granted, and in addition to that was the right to put up a garage on that piece of ground. Obviously, when the person exercised the right, built the driveway and put up the garage, the claim, the fight was on. And the claim by the person bringing the lawsuit was that the garage, because it's locked, is adverse to my rights and is not an easement. And the court said, well, yeah, except for the fact that why the hell would you have a garage if you weren't going to lock the door? And it's in the easement, and it was a permitted use of the easement when it was originally written. So, yeah, we're going to allow complete exclusion of the real owner from this easement in the case of the garage. So, and that was an incremental but very important step forward in judicial thinking in California, because now you've got a way to prove that the common use would be to exclude the real owner. Now you've got a way to claim prescriptive rights at least and actually exclude the owner like you actually own the piece of property.
How recent is that case?
2008?
Prior to that, the courts have been very hesitant.
Yes. Yes. Exactly. And the common example is a landscape easement. Okay, we got a landscape easement. I fence it, and I'm occupying 10 feet of Joe's property, and I'm growing my prize roses on it. And I go in there and, wow, I want a landscape easement. Or I'm claiming this by adverse possession. Nah, you haven't paid the taxes on it. Okay, I want an easement. Well, let's see, are there any gates in that fence? Can Joe get into that property? No, so it's being held entirely exclusory to everyone, including the real owner. No, we're not going to give you an easement. Get your fence down.
Then I say it's okay to have the roses there
If you say it's okay to have the roses, now I have a license and I get to use it.
until I give you the boot.
Exactly. And of course, Joe never would, because we're really good friends. That's why we sue each other all the time. Practical location. Practical location is exactly what it says. I have a right to a road over this piece of Joe's property. It's a freaking cliff. I don't know who wrote that land description. Couldn't have been a land surveyor, probably a title person or an attorney. So I'm going to put the road down along the bottom of the cliff where I can actually use the damn thing. Practical location. Joe sells the property. Whoever comes along down the road says, hey, this road isn't where the easement is. Hey, get him off. And I say, I can't use the road where the easement is. It was in error. Practical location puts it down at the bottom of the cliff. The court says, you're right, and gives me title to it as an easement. Or maybe it's full ownership. Just because there's a decision at the superior court level doesn't mean it's the right decision, because remember, they usually work on equity, like slicing the baby. A lot of times, if you look at the original opinion and read the original opinion from the superior court, you've got a piece of property 5 feet wide in dispute between two guys. The court likes to play Solomon, split it down the middle. Nowhere in law is that a possibility, unless Joe and I agree with that. It's one line or the other for various reasons, but not down the middle. But you see that all the time in superior court decisions. Just because it comes out of a superior court doesn't mean it's right. It means it might be equitable, or he might just be trying to piss us both off to the same amount. Estoppel. This is a really weird, sometimes very hard to understand concept. Estoppel means that if you say something and I rely on it, you can't later go back and renege on that and say, I didn't really mean that. An example. Joe and I have two pieces of property next to each other, and I'm building a house. And both pieces of property are undeveloped. There's nothing developed around it. For whatever reason, my contractor starts building on Joe's property. Joe comes by there daily and goes, yeah, well, it's looking pretty good. Yeah. And off he goes. House gets built, and I've got the moving truck, and Joe comes up and he says, get the hell out. That's my house. It's my property. Real case. The court said, you knew it was your property. You should have made the statement when you saw the thing happening. You don't have that piece of property anymore. Switch properties. Had he not shown up, there would have been a whole different set of circumstances there, and it would have been a really, really interesting sort of a deal. So anytime you make a statement and I rely on it, the court says, that's fair. You can't go back on it later on.
Might be damaging friendship. What friendship?
Possible. Joe's really thick-skinned.
Can I have a question on
Yes.
thorough agreement?
Yeah.
Like, if I own this piece of property, but I don't really own it outright, it's a mortgage. Let's say my mortgage,
Yeah.
I have a trustee, and I make this oral agreement with my next door neighbor for doing whatever it is. Would that be valid?
Might. You make a very good point. Trust deeds are potentially a real problem. If you and I own property next to each other and we come up with an agreement as where we're going to put that line, whatever we're doing with it, we adjust the line and we don't include the title, the beneficiaries, the trust deed holders, we could be in trouble if there's a foreclosure. And I put that underneath there because that's one of the things that I want to talk about when we talk about lot line adjustments in a little bit. It's a terrific question. We'll address it under that if you can hang on. I promise we'll get to it.
Under prescriptive rights, you had talked about the situation where the basketball court had been in use forever.
Mm-hmm.
If that property had been staked no trespassing forever and they were still over there, does that give any difference?
It can do. There are specific requirements for how to post that and how frequently to post that. And if you post them at 251 feet, you're in violation. I'm going to definitely point that out and have my surveyor measure where the location of every one of your signs is. And if they're difficult to read, you're going down. If they're 1 foot over the distance, you're going down.
So regardless if that was fenced and they were climbing a fence, it doesn't matter?
Yep. Yeah, because unless you take that basketball hoop down, that's now an attractive nuisance. I'm going to climb over your fence to be able to play basketball.
Yeah, this might fall under trust deeds, but if you make a statement saying your property corner is such and such, without including other private property owners, is that the same thing or is that different?
That's different because trust deeds are handled differently than grant deeds. Trust deed is based on money. The grant deed is based on ground. The money is backed by the ground, and the ground is backed by the money. But
Can one individual, if there's multiple owners on a lot, can one individual make a claim to where that property corner is without involving the other ones? And would that be held in court or?
I'm not following that. You have.
If someone makes a statement under estoppel about your property without including the other 7 owners on a property lot or something like that, does that hold in court? Or is that?
It might do. So what you're saying is you've got joint owners of a single piece of property, and one guy says this is the property corner, and it's wrong.
Yeah.
Could he be held to that later on? Depends. Depends upon how good the attorneys are and how much money you got. So let's face it. Justice goes to the guy with the most dollars and the best land surveyors in many cases. And it doesn't really have to be the best land surveyor. It's the guy who gets his case across the best. The first time that I was ever involved in a lawsuit where I was an expert witness, the attorney, my attorney, worked over trial testimony. And it was basically in order to, for me, he was going to elicit my testimony in such a way that we were going to teach the judge what he needed to know to be able to make the decision the way that we needed him to make that decision. And we practiced and practiced and practiced. And he finally got a couple of the secretaries and plopped them down and says, okay. And then at the end of that said, okay, well, what does that mean to you guys? And we used that to adjust the testimony to be able to teach the judge what he needed to know to make the decision that we needed him to make. So it's not necessarily the best land surveyor, it's the guy who can communicate best and teach the judge the best. Was there another question over here?
Did that work?
Actually, it did. And that was September 11th of 2001. And it was in Independence, California. And he was in federal court. And just after I'd been seated, the bailiff came in with a note and whispered to the judge, and the judge turned around to both the attorneys and asked how long my testimony was going to take. And they both said a couple of hours at most. And he looked at me and said, "Can you come back next week?" And I said, "No, actually, I'm getting married on Saturday, and I'm going to be on my honeymoon in Mexico." He said, "Great, okay. We were just ordered to close all the federal courts because of the 911. We're going to stay open to hear Mr. Wilson's testimony." And they did. To our knowledge, to my knowledge, that was the only courtroom in the United States that was open. So, when you're an expert witness, judges really do treat you very well. They treat you like a rock star, that we really are. Gene Simmons. So yeah, it did actually work. We are right up against a break, and the next part of this is going to be junior senior rights. So I think before jumping into that, we'll just say we're going to talk about junior senior rights, and we'll see you in 5 minutes?
30 minutes.
30 minutes.
5 minutes.
30 minutes?
10 to 10:30, yeah. 5 times 6, 30.
Okay, gotcha.
Or, Ian, we can do 3, 0.